all for coming. How's everybody doing? Good, that's good. My name is Dan Hartman. I'm the president of the Cornell Chapter of the Federal Society. I know we have a lot of 1Ls here. I'd like to welcome you guys to Cornell. It's a great school, and I hope you guys will get more involved with us, and hope we've got a great event in store. First, I'd like to introduce you guys to the Federal Society. We're a group of conservative and libertarian students here at Cornell, but what we really focus on here is promoting debate. You'll see here we've got two great constitutional scholars on both ends of the ideological spectrum, and that's what we're here to help serve, and we're glad that you're here to help join. For people strolling in, there are some empty seats in the front, some empty seats right here. Please feel free to come down. The first thing I would also like to invite you all to our first meeting. It's going to be a week from tomorrow on Wednesday, September 12th at 4 p.m. in a room that is yet to be determined, but that will be out through an email. I'd like to also thank a few people to begin. I'd like to thank Professor Michael Heiss, who's our advisor. He's been great. Our Vice President, Ross Fox, who's outside helping patrol the food. Our Treasurer, Dean Caravana. The Bioethics and Health Law Society presidents, Nicole McNeil and Ross Weinstein, who have been great at co-sponsoring this event. And particular mention for Byron Crow here, who Ilya was Byron's boss over the summer. So Byron helped hook us up.
To the extent you like you like him, I taught him that. To the extent you didn't, he just, these interns,
He's a great intern, I'm sure. And then for the speakers, I'll also like to welcome Dean Schwab, who's come. Thank you for all your support. And so for the speakers, I'd like to introduce Ilya Shapiro. Ilya Shapiro is a senior fellow in the Constitutional Studies at the Cato Institute, and he's editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was a special assistant advisor to the multinational force in Iraq on rule of law and practiced international political, commercial, and antitrust litigation at both Patton Boggs and Cleary Gottlieb. Shapiro was contributed to a variety of academic, popular, and professional publications, including the Wall Street Journal, USA Today, the Weekly Standard, the New York Times, as well as CNN, Fox News, and the Colbert Report. He holds an AB from Princeton University, a master's from the London School of Economics, and a JD from the University of Chicago Law School. Next is Professor Michael Dorf. He's co-authored books on the Constitution with Lawrence Tribe and Trevor Morrison. Professor Dorf writes a bi-weekly column for Justia's free web magazine Verdict and posts several times per week on his blog, Dorf on Law. Professor Dorf served as a law clerk for Judge Stephen Reinhart of the United States Court of Appeals for the Ninth Circuit, and then for Justice Anthony M. Kennedy of the Supreme Court of the United States. Prior to being at Cornell, he was a vice dean at Columbia Law School. He is a graduate of Harvard College and Harvard Law School, and spent the year between college and law school as a Rotary Scholar at Victoria University of Wellington, New Zealand, studying physics, of all things. Most importantly, Professor Dorf is an all-star.
But today's debate is on law, is that correct?
Okay. I've forgotten it all anyway.
Most importantly, Professor Dorf is an all-star intramural basketball player on Cornell's intramural basketball team. Yeah. So our topic today is the Obamacare decision. For those of you who watched more than the first 5 minutes of CNN's coverage, the individual mandate was upheld under the taxing power. And we'd definitely like to hear, we'd like to go through a few parts of the decision, and we'd like to start with the Commerce Clause and taxing power, but definitely are open to opening words from Ilya and Mike. So we'll start with Ilya.
Great. Well, thanks so much for having me. This is my first visit to Cornell, which means I guess that Dartmouth wins my personal Ivy League tontine, the only one I haven't visited yet. But so far, this is gorgeous. I'm not even talking about the T-shirt or whatnot. I mean, it's a beautiful place. I'm sure if I came back in the middle of February, I might have a somewhat of a different opinion. But anyway, look, I've been heavily involved in this for the last, occupied 2/3 of my time the last 2+ years. I filed 10 amicus briefs, including 4 in the Supreme Court, one on each of the issues, and I've kind of consulted with the various plaintiff groups, and along with Randy Barnett, I think we're the only people not in the Solicitor General's office to have attended all of the appellate arguments. So I and Cato, indeed, have had a big stake in this case, which I think is going to be, y'all are still just starting out or in the middle of law school, but this is the case of a generation, if not a lifetime. It goes to the heart of the relationship between the citizen and the federal government and the states. Brings up a whole host of issues that are going to redound both in law and politics for a long, long time. Now look, there's a word for people who predicted that it would be decided, the case would ultimately be decided 5-4 with Chief Justice Roberts going over to join the liberals and Justice Kennedy vehemently in dissent. That word is liars. There's a word for those who think that furthermore that'll be decided, upheld, the mandate will be upheld under the taxing power, and that's damn liars. And there's a word for those who further to that thought that the court would nevertheless strike down the Medicaid expansion, or at least make it an opt-in. And I guess the only thing we're left with there is statisticians, right? I mean, nobody predicted this. I was sitting there, all the experts, liberal, libertarian, conservative, nobody quite predicted this. And as I wrote after the case was decided on SCOTUS blog, we, meaning those challenging the law, saying this was an abuse of federal power, nobody got it right. Everybody was gobsmacked. And yet, nevertheless, we won everything but the case. That is, on the constitutional law, my position won out. I mean, the Supreme Court did not say anything to contradict any of the briefs that I've been filing. Luckily, I wasn't in charge of the taxing power bit. But we have a resounding emphasis that, indeed, Congress cannot compel activity in order to regulate it. It cannot compel commerce in order to regulate it. It cannot regulate inactivity. It can prohibit existing activity or regulate it, but not compel new types of activity. That went further than any of the lower courts. None of the district or circuit courts that ruled for the challengers adopted those kind of articulated bright lines that we had been pushing. On the necessary and proper clause, even if the mandate was necessary to, there's some question about whether it was necessary to a regulation of interstate commerce, but even if it was necessary to the national regulatory scheme that Obamacare was, it's not proper. We've never had something like that, a statement that so strongly that something has to be proper, not just necessary. Those are big wins. And then on the spending clause, which we'll get into, but since the New Deal, under modern jurisprudence, no federal legislation has been struck down under the spending clause. And here we got 7 votes for that proposition. So that's historic. And yet, the individual mandate and most of Obamacare was upheld under the taxing power. But in a way, I think that the Chief Justice consciously wrote that to be a ticket good for this train only. That is, this never before seen, never to be seen again. I call it the unicorn tax. The way that he justified it was that he rewrote the law to make it justified under a tax in a way that, first of all, someone's not violating the law either way. Okay, because if you're violating the law and then getting punished, that's not a tax. That's a regulation or a penalty or a fine. The penalty, the tax, the unicorn tax, is so low that people can make a reasonable financial decision rather than having this tax penalty thing be prohibitory, which means that if Congress, once it realizes that any rational person will pay this tax rather than the much higher cost of actually buying qualifying insurance, if Congress ever tries to raise that penalty tax, all of a sudden that's unconstitutional because that would then be coercive or compulsive or prohibitory. There's no scienter requirement, no willingness or knowingness that you're violating the law, and it's collected by the IRS through a normal means of taxation. Now, I have a lot of problems with this. I have kind of a top 10 list of problems with the Roberts analysis. He says there's a choice involved. You can either pay the tax or you can buy insurance. Well, if that's not scienter, I don't know what is, if you're willingly making a choice. The IRS enforcement, well, that doesn't really matter because it's not about who enforces it or what it's called. It's how it functions. I can go on. There's he says it's not a direct tax. Well, then what kind of tax is it? The Constitution only allows imposts, duties, excises, income taxes, thanks to the constitutional amendment, and direct taxes. If it's not a direct tax, I guess it's an excise tax on the privilege of not buying insurance or something. It's unclear. On the one hand, Congress cannot regulate inactivity, but it can tax inactivity. This is the first ever tax on status that's nevertheless not a direct tax. I mean, there's a whole lot of problems, and I think that's because fundamentally this was an illegal decision, or rather 8 justices decided this case on the law, 4 that I agree with, 4 that I disagree with. There's that fundamental clash between those who think that the Constitution's structural provisions put actual limits on federal powers and those that think, well, there's a national solutions to national problems clause to the Constitution. Don't take it from me. Justice Ginsburg, in her dissent, said that constitutional structure must yield to, quote, Congress's capacity to meet the new problems arising constantly in our ever-developing modern economy. So the structural limitations don't really mean anything if Congress really, really needs to fix something. So anyway, that's the competing clash. And then one justice, the chief obviously I'm referring to, decided on something else. At some point, he posed himself the conundrum that he needed to uphold the law while not expanding federal power. And he did this by rewriting this provision, which is clearly a regulatory provision, was never intended to be a tax, doesn't operate in the way that the other revenue-raising provisions of Obamacare do, in a way that doesn't apply to any other tax. And I think that's unfortunate, this use of strategic or political, not in the partisan or anything else considerations, but strategic, opportunistic considerations to uphold something rather than on the law. So in the long term, obviously the country is harmed in terms of having a worse health care and economic outcome, but the Constitution is much, much better off in ways that we'll continue discussing.
So I want to begin by thanking the Federalist Society for inviting me today and for inviting Ilya. Dan's right. They do. I mean, I'm not a member of the Federalist Society. I oppose most of the things they favor in terms of substantive views. But it's a wonderful organization in terms of what they do on law school campuses. And I think it's a testament to the strength of the organization, and maybe, I'll puff a little bit, to my own teaching that all of their officers seem to have been my small section students from last year. I mean, literally, this whole front row, except for Dean Schwab. So they are really committed to robust debate, and I think that's terrific. What I want to do in my sort of opening statement is I'll talk a little bit about commerce and a little bit about taxation, and then I think we agreed we'll go on to the spending clause issues a little bit later. But I want to frame my discussion around the question of whether the case mattered. And my view all along, from the moment that these cases started percolating through the lower federal courts, was that this case mattered, that the political stakes in this case were incredibly high, and that the constitutional and legal stakes were actually quite low, although they would appear high. And as things turned out, I think that continues to be the case. We know why the political stakes were high. The political stakes were high because the Affordable Care Act was one of, if not the signature domestic policy achievement, whether you like it or not, of a first-term president being challenged in the Supreme Court during an election year. And so if the law was either struck down or upheld, that was going to have very important political ramifications, especially given the sort of high-profile clashes between the president and the court over things like campaign finance as well as this law. So the political stakes were high. Why do I say the legal stakes were low? Well, I think the legal stakes were low for reasons mostly identified by Ilya, Randy Barnett, and other people challenging the law. Their contention was that Congress never, in the 220-some-odd-year history of the United States, had ever passed a federal law mandating activity, right? That this law was unprecedented and unique. Now, much of the disagreement in the Supreme Court was whether that characterization was accurate. You know, what to make of the Militia Act passed during the early days of the Republic. How to characterize the Agricultural Adjustment Act upheld in Wickard against Filburn, the point of which was to encourage certain activity, namely the purchase of wheat, even though the mechanism it used was not directly a mandate, right? So there was a debate about how to characterize some of the precedents to determine whether the plaintiff's characterization was accurate or not. And I think my own view is that was an open question. I took the view of the people defending the law, but I understood that one could make a plausible argument, as the plaintiffs did and as 5 justices agreed, that it was an open question whether there was this direct mandate power. And you could then resolve it either way. The Supreme Court is constantly resolving open questions by making up an answer. That's what they do, right? That's why we have a Supreme Court, okay? So if we accept this characterization that never before in history had Congress done this, then it is an almost totally unimportant question whether Congress can do it going forward, because Congress has been able to achieve just about anything it wanted to achieve without a mandate power, right? The only reason why it was an issue in this case was because Congress sort of assumed they had that power and acted pursuant to it, and we don't have a legal system in which they could get a definitive answer from the Supreme Court as to whether that was permissible before there was an intervening election and their membership changed, and then they could try to do it some other way. So if you think that this was unprecedented, then what you've established is Congress is never again going to use a power that they used exactly once in the history of the Republic. To which my answer is sort of, well, okay, big deal. So that's why I don't think the case is very important, except perhaps as a signal about federalism more broadly, right? That is, going forward, this could be a signal that the gloves are coming off now, and the court, which under the late Chief Justice Rehnquist had seemed to be serious about federalism limits and then had pulled back, may be going to be serious again. But as a signal, that's not inherent in the doctrine. That's in the minds of 5 justices of the Supreme Court. So that's with respect to the importance or non-importance of the case. I will say one further thing about the Commerce Clause point, which is that much of the case against upholding the law under the Commerce Clause, and it was repeated by Ilya today, rests on the proposition that the people supporting the law could not come up with a limiting principle. During the oral argument, Solicitor General Verrilli had a hell of a time and really didn't do a very good job of answering the question, well, what can't Congress do if it can mandate activity under the Commerce Clause? I think there are 2 good answers to that. One is to understand what Justice Ginsburg was really saying in that language that Ilya quoted for you. I read her not as saying Congress has no limits under the commerce power, but to be invoking her longtime teacher and friend, the late Herbert Wechsler, who wrote famously that the limits on Congress are enforced principally through the political safeguards of federalism. That is to say, there are structural mechanisms in how Congress and the federal government are put together that ensure the protection of for the states. And so it's not necessary for the Supreme Court to exercise its extraordinary power of judicial review to do that. So I read her not as saying there are no limits, but Congress is the guardian of those limits. Now, that has been subject to for a long time to a criticism that says, well, Congress can't be trusted to police itself. I think that we can debate that. I think that periodically you do see members of Congress running for office on a federalism plank, suggesting that they are interested in policing themselves. But even if you think that Justice Ginsburg got it wrong, that she and Herb Wechsler and all the others who say Congress should police itself on matters of federalism, even if you think they got it wrong, then the question is it possible to articulate a limiting principle? And my answer is yes, even though Solicitor General Verrilli blew it. And the principle is pretty simple. It comes from the Supreme Court's existing Commerce Clause jurisprudence. Whatever, and I'm just making this up now. Actually, I'm making up in a paper I'm writing. But, you know, it's free for you here. I'm unveiling it for the first time. Right? Whatever Congress cannot prohibit or regulate because it's not economic activity, Congress cannot compel. So let me give you an example of that. A number of localities around the country have so-called must-carry laws. These are laws that say that you must go around armed. Suppose Congress were to enact a national must-carry law, a law that says you commit a crime if you go out in public not in possession of a sidearm or other firearm. Right? It seems crazy, but you know this is Congress we're talking about. So if Congress were to do that, would that be within the scope of the commerce power? Well, today it wouldn't be because the Supreme Court has said Congress lacks a mandate power entirely. But even if the court had upheld the mandate under the Commerce Clause, my view is that still would have been invalid, not because it's a mandate, but because what it mandates is something the Supreme Court has already said is not economic activity in the Lopez case. Right? So the answer to the question of whether there are limits on the commerce power if you accept any mandate power is yes, and the Supreme Court has already articulated them. Unfortunately, I only thought of this example after the case was decided, so you know, history would have been different otherwise, perhaps. Let me say just one word about the taxing power portion of the decision. It's easy to see the case as 5-4 on the taxing power. I think that's a mistake. As far as the Constitution is concerned, the case was decided 9-0 on the taxing power, upholding not the particular mandate as a tax, but the power of Congress to impose mandates as taxes. That is to say, even the dissenters acknowledge that Congress can give people financial incentives to undertake activity it could not directly compel via the Commerce Clause if it does so properly through the tax code. So imagine that that Chief Justice Roberts had gone the other way and that the composition of Congress had not changed after enactment of the ACA and they were interested in reenacting the mandate. Right? How might they have done so? How, in other words, could you write a mandate that satisfies the 4 dissenters? Well, you would do it as a refundable tax credit. Right? Congress has the power to tax income. It has the power to give people deductions and credits for activities that Congress wants to foster. And so it could do it that way very, very easily. You wouldn't even need to make it a refundable tax credit. A refundable tax credit means that even if you don't pay any tax, you get it, because people who are making so little money that they don't pay any tax are not going to be subject to the mandate anyway. They're going to be covered by Medicaid, subject, of course, to the spending clause holding, which we'll now discuss.
Well,
now's the time for you to applaud for me.
3 quick points on that before I move to the spending clause. First of all, it's really interesting how now I'm not saying Professor Dorf has done this. He's been a legal realist the whole time. But this whole idea of the legal stakes being low. Well, we've sort of been saying that in the sense that if we win, all we're saying is that Raich versus Gonzalez, the existing Commerce Clause and Necessary and Proper Clause precedent, that far and no further. It is the supporters of the individual mandate that were saying, well, you know, if these challengers, crazy Tea Party radicals win, then all of a sudden, you know, there goes the EPA, there goes the Clean Water Act, there goes everything that's left over from the Great Society or the New Deal, and moreover, I mean, they might have watched Hunger Games too many times. Kids will have to start laboring in mines, and it'll just be crazy, and that's simply not the case. I mean, yes. The original case, if we're taking the Constitution as written, as words, the constitutional text for what it means, then this is an easy case. Obviously, most of that a lot of that constitutional legal edifice would have to collapse. That's what Thomas wrote in his short dissent. But the challengers didn't say that. They said that we take everything that came before as a given, and this goes even further. So yes, I believe that the Commerce Clause victory was real, Necessary and Proper Clause victory was real, but it certainly doesn't roll back any of the abuses of the last 70 years. Now, the views of the Academy indeed were that there were no real limits. I mean, these political checks, I mean, that's a practical check, but unless you're against Marbury versus Madison, the whole idea of judicial review, the idea that judges are supposed to be providing a separate and independent check against political actors, then that stuff has to mean something, because we didn't have a Bill of Rights originally. The original Constitution wasn't supposed to give government unlimited powers unless there was, unless it infringed some other explicit prohibition. My vanity plate on my car is Fed 51 because I like Federalist Paper 51 so much. I believe that the supreme role in a world where men govern men rather than angels being somewhere in a utopia is you first empower the government to do certain things like raise armies. That was a problem during the Articles of Confederation, like striking down interstate barriers to trade, the purpose of the Commerce Clause, right, to make commerce regular. Unless you have a federal government to do, have it do that, and then you check it beyond that. And now the limit that Professor Dorf now proposes is essentially an inverse Bill of Rights. So whatever Congress can't do because it infringes on the Bill of Rights in terms of a regulation or a prohibition, all of a sudden it can't do in terms of a mandate. I mean, it's still tied to some other type of extra structural check, it seems like to me, but I'll wait for the paper to have my definitive statement on that. As far as the tax credits versus debits thing goes, I mean, that's too cute to say that there's a 9-0 decision based on that. First of all, the dissent said, yeah, Congress could have done any number of things that would be constitutional. They could have made it Medicare for all. They could have added a new payroll tax to pay for Obamacare. They could have raised everybody's income taxes. Or indeed, they could have given us a tax credit for buying health insurance, like they give us tax credits for putting solar panels on our roofs, or buying an electric car, or mortgage interest deduction, right? There's all sorts of tax credits in the system. But a credit is different from a debit. A credit is relief from a generally applicable law, generally applicable tax. There is no general health insurance tax from which people who buy are then relieved. To think of it some other way is to conceive of the government as having, from the beginning, claims to 100% of all of our income, of all of our wealth, and through some sort of noblesse oblige, let us keep some of that. That conception, I mean, I'm stylizing it rhetorically, but that conception has been definitively thrown out by the court again and again and again. Most recently, 2 years ago, in an Arizona school tax education credit case, Axto versus Wynn. There's a ringing language from Justice Kennedy on that. Anyway, enough about that. The spending clause. Just so everyone's on the same page, what did, and this you'll need to know for the bar or what have you, what did the court actually say about the spending clause? 7 votes, by the way, 7-2, including Kagan and Breyer, who were the most skeptical about the state's argument with respect to the Medicaid expansion. So what were the states saying? They were saying that, look, you're conditioning these us accepting all of your new regulations and expansions of Medicaid programming, which we're saying to you, court, is going to be burdensome and bankrupt us and really force us to change our legislative priorities. We have to accept that or forego not just new money that's coming under Obamacare for Medicaid, but all existing Medicaid monies. And we didn't know that this was going to come down the pike. When we signed up, whether it be in 1965 when Medicaid was first enacted, or the last state, Arizona, joined Medicaid in 1982, it was a completely different program. And now this other thing is being forced on us. And the court agreed by 7-2. And here is what seems to me like the black letter law coming out of this for future on what the standard is for when the strings tied to federal funds are too coercive as to be beyond the very broad spending power. So first, you have to court. It's not even it's black letter, but it's not a bright line. There's a kind of things to evaluate. The court said that whatever the exact standard is, this goes way beyond it. So you look at the size of the grant that would be withdrawn. In South Dakota versus Dole, the last big case about the spending clause, only 5% of highway funds were at stake. Here, all Medicaid monies, which are crucial. That's important. Whether the conditions make the law, quote, in reality a new program, or just transform the program. I mean, lots of wiggle room, lots of jobs for lawyers, for all of you in future to argue about these things. Does this transform fundamentally the program? Is it just modifications, tinkering around the edges? Whether states are threatened with loss of existing funds or just new funds. That's pretty black letter. That's pretty bright line. Okay, so if you're imposing new conditions and tying not just new funds, but old funds, existing funds, that might be something like, akin to the court engages in sort of analogies to contract law, might be unconscionable or a contract of adhesion or coercive. And finally, whether the conditions govern the use of funds or threats to terminate other grants. So is it just regulating how these funds can be used, or is there something else going on? And I think that makes sense. I mean, again, it's not a bright line rule. So there's lots of room for future litigation at where the rubber meets the road in much closer cases. But here, this seems to me, and the court's margin reflected it, a very clear thing that the states certainly didn't sign up for this whole program that was going to reconfigure the national provision of health care rather than what Medicaid originally was providing health care to the disabled, the blind, the elderly, and eventually needy families with dependent children. So that's why this was a transformation. Interestingly, Roberts rewrote the law to save it. I agree with the joint dissent that the whole thing should have fallen if the Medicaid expansion was indeed coercive. But he wrote the law to make it an opt-in, and so that complicates things tremendously in terms of how the different other parts of Obamacare interact, the different employer credits. I won't get into that, but it makes states' decisions, policy making, economics tremendously hard, and we're going to have effectively a patchwork quilt of Medicaid provision, which is certainly not what Congress intended. So it's you get a result that nobody really wanted, not the opponents, not the supporters of the national law. But I agree with the new standard that's been set under the spending clause. It matches what not just Cato but a lot of groups were filing, and the remedy is just there's this weird patchwork of things that we'll see what happens. But anyway, there we are. That's the new standard, and I agree with it.
Okay. Let me just say 2 words about the sort of back and forth on our previous topic, and then I'm going to I want to pose a question for Ilya. Just to be clear, neither Justice Ginsburg nor I created this view of political safeguards. It was Herb Wexler, who was quite a moderate conservative legal scholar. It was adopted by the Supreme Court in the Garcia case, which has never been formally overruled, although it's certainly been undermined by subsequent cases. And the idea is not inconsistent with Marbury. The Marshall Court never struck down any act of Congress as beyond the enumerated powers. Its most famous opinions, McCulloch, Gibbons against Ogden, are known for the expansive view of federal power, specifically because they defer to Congress in understanding its powers as time goes forward. Now, that's not to say that the Wexler view has ever been law to court, but it is not some view in which the court abdicates its responsibility. Second, I wanted to be clear that my proposal, which will be in this paper that Ilya is going to read with care, and all of you will read, of course, as well, it's not an inverse Bill of Rights. It's applying the Supreme Court's own Commerce Clause decisions with respect to prohibitions, things like prohibiting guns near schools, prohibiting gender-motivated violence, to mandates as well as prohibitions. The reason I think the court couldn't do it is because of a mistake Justice Stevens made in the Raich case, where he gave a too broad definition of what counts as economic activity. But that's sort of inside baseball. Let me say a word about the spending power. It seems to me that you guys are are not nearly as ambitious enough in the way you should be attacking the spending power. The current doctrine is a kind of, well, we know it when we see it. You can use the spending power coercively, but you can't go too far. It seems if you were principle, you would adopt something like the proposal that Lynn Baker of Texas has advocated for many years, which says that Congress can limit, can attach strings on the particular funds it's giving to the states, but cannot condition those funds on doing something else. Right? So if Congress gives you some money, if they're going to reimburse you, you got to show you complied with the conditions that they set, but that's it. You can't. So on this approach, South Dakota against Dole is wrongly decided, right? Because that wasn't money for implementing a minimum drinking age. That was money for the highways, which was only loosely connected. So that would be a principled line. The line you actually get from South Dakota against Dole and now from the ACA case is, well, Congress can attach strings as long as those strings aren't super duper effective. And it seems to me that all of the outer limits that the court announces in the spending clause portion of the decision are kind of, know it when I see it. And to me, the most preposterous one is this limitation that you can't limit existing funds, right? Justice Ginsburg is I think absolutely right when she says there's no such thing as existing funds. Those are funds that were appropriated in previous years, and what the ACA Medicaid provision did was not to reach back and say you have to give up money that you got in 2011 if you take the money in 2012. It says if you take the money in 2012, or let's make it more realistic, in 2014, then the 2014 money that's like the 2012 money that you got is now subject to the new conditions. And she poses the following hypothetical, which I'd like to pose for you, because the majority doesn't answer it. Suppose instead of...
The majority of 7 now we're talking about.
That's right. Kagan and Breyer are, out to lunch on this too, right? Suppose that that Congress, instead of attaching new conditions to so-called old funds, had simply in one bill abolished old Medicaid and created Medicaid, right? Which was old Medicaid, but plus the new provisions with all of the conditions. It would have been functionally indistinguishable, and you couldn't have said it's attaching conditions to existing funds because those funds are taken care of already. Is that invalid under your view? And if not, why not?
That would throw chaos into the system, but unless there's some sort of reliance interest where you would have the states suing the federal government for, I don't know what. I mean, it would complicate things, but I'm much closer to the position that would be okay for Congress to do than not.
So the problem, the constitutional flaw is that they continue to call it Medicaid.
That they did not run the political gauntlet. There are certain things that are constitutional, but that would take a lot of political heavy lifting, like, for example, passing taxes. The taxing power is broader than the commerce power. And so if Congress had passed the mandate as a tax, it would have been scot-free. But because it didn't run that political gauntlet, and similarly here, it did not run the political gauntlet of repealing Medicaid and enacting Medicaid, that would have been a different legal analysis altogether. I don't see why that, recognizing that, impugns the majority's analysis of once you have us over a barrel, trying to extract other things from us is coercive.
Because it's the same barrel. I don't see why it's a harder barrel to get off of because it's called Medicaid than Medicaid.
Well, again, we're not about labels. It's not about whether the mandate is called a tax, a penalty, a rutabaga, or anything else. It's not the Medicaid, Medicaid. It's structural things, and judicial review works in concert with the political checks to limit federal power in that manner.
So I think 6 months ago I would have agreed with you, but it seems to me in our current political culture, people will accuse you of raising taxes or not raising taxes or whatever, and they'll just make stuff up anyway. So I think Congress is clever enough that they could do things under the taxing power and then not call it a tax for political purposes. And conversely, even if they honestly don't call it a tax, they'll be accused of raising taxes in any event. So I guess I'm not as confident in you as you are in the political checks. And as long as you're confident in those political checks, why aren't you confident in the political checks that Herb Wexler identified 50 years ago?
Because the Constitution limits federal power in certain ways and not in others. I mean, look, Medicaid itself is problematic ab initio. So you're posing to me a second-order problem based on first-order
It's
principles of
problematic
originalism.
to provide for the general welfare by providing health care for the poor.
Now, you know just as well as I do that the General Welfare Clause doesn't say that Congress can just do whatever it's doing as long as in good faith or not it's acting in the general welfare. That's an actual limitation that what Congress does through its various other 17 enumerated powers has to be done for the general welfare or to promote the common defense. And that is, you can't build a bridge to nowhere or serve a parochial interest. Again, I'm just telling you what the Constitution says, not what modern constitutional law has put a gloss on it.
It seems to me that that's entirely gloss, right? Because certainly you agree that the federal government could run Medicaid directly. It doesn't do it. It does it as a joint federal-state program.
Under existing precedent?
Under the power it's got, right?
Are we talking 2012 or are we talking 1920?
1791.
Oh, definitely not.
Congress could not take taxes. I mean, we'll retroactively give them the 16th Amendment, the ability to take.
Now we're getting really out there. We're going to stylize a constitution that he wants.
No. Fine. Put it in 1900 if you want.
Okay.
Right. Congress imposes the income tax.
1900 is before the income tax.
Sorry. 1920.
Okay.
Yeah. Good point.
25. When was the amendment?
No. Whatever.
Keep going.
We can make it your favorite year. I don't know, 1931
36?
or something.
Okay.
Yeah. So Congress imposes an income tax and uses that money to give poor people health care. You're saying Congress couldn't. You're doing it directly as a federal program.
Provision of health care is a local thing. It's not a national thing.
And that's because there's no health care
Because
power?
we haven't yet decided, Wickard, to aggregate local activity in such a way.
So this goes back to your viewing the last 70 years as, quote, abuses.
Of course.
Okay. I think we're ready for
Great,
questions.
thank you.
Most of it.
So, thank you very much. That was great. And I definitely want to open up to questions, but I'm going to be greedy and take the first one. And then after questions, I want to invite Dean Schwab up to say a few closing words. So my first question is, if the Republicans sweep Congress in November and there's a President Romney next year, how feasible is the overturning the health care bill, which is what he's running on very much? I don't know if we want to start with Ilya and then Mike, or...
Sure. Now, I'm a simple constitutional lawyer. That goes into the realm of political prognostication and even Senate parliamentarianism and things. But here, look, if the Republicans do sweep Congress, by that I mean hold the House, win a majority but not filibuster-proof majority in the Senate, and Romney wins the White House, they will have a mandate to repeal Obamacare. That's what they're all running on. The only question is whether that non-filibuster-proof majority, a simple majority in the Senate, is enough to repeal Obamacare. So it really does come, will the Republicans have spines to actually do what they promised they would do? That's also an even bigger open question, I suppose. I asked Orrin Hatch, who's been around in the Senate for a very long time, about, not about the politics of it, but about the procedure. And it turns out that tax bills are not subject to bills to raise revenue, tax bills, are not subject to filibuster, not subject to a requirement to get 60 votes to get cloture, to end debate in the Senate. You just need a majority, whether that be 51 or 50 plus Vice President Ryan. And so given that Obamacare is now a tax, so say the Supreme Court, or at least the individual mandate is, and probably most of it can be attached to it. I guess we'll have some sort of meta discussion about inverse severability or something, about how much of it can be attached to that individual mandate unicorn tax. And then it's only subject to that 50-vote rule, assuming the Senate parliamentarian, which will be a Republican in this scenario, votes out of order the Democrats' points of order that they will raise, saying that it is subject to cloture. So I think it's very feasible. Again, but if you believe that the Republicans have spines, so maybe not as feasible, but
Yeah. I mean, the bill originally was enacted, you'll recall, through a non-filibustering process, reconciliation, because Scott Brown had by that time become the senator from Massachusetts. So, there is, you could make an argument for that sort of thing. I think the more interesting question in some ways is what, if anything, would they replace it with? I've heard Eric Cantor say that the Republicans are interested in keeping some of the more popular pieces of the bill. And, so some of that you can do relatively cost-free, right? Like the provision that enables parents to keep their adult children on their health insurance until whatever age it is, 26 or something like that. That they'll keep that. But the key one, of course, is the prohibition on insurance companies screening out for pre-existing conditions. And I heard him at least once say, well, yeah, we're in favor of keeping that provision as well. Well, that's the whole enchilada right there, right? Because that's why the Congress that passed the ACA also passed the mandate, because if you have prohibition on screening out for pre-existing conditions, then you've got to deal with the adverse selection problem. That's how they dealt with it. So I think it's quite possible that you would get, Romney Care 2 described as a total repudiation of Obamacare, but would look a lot like it on the sort of key provisions.
Because the healthcare ruling in the opinion, they didn't necessarily need to decide the Commerce Clause question in order to reach the tax question and hold it. How vulnerable do you think the decision is going to be in the future to being characterized as dictum? And I'd like to hear both, because this isn't something I've heard a lot of people talk about.
So there's two kind of similar points. First of all, is the Commerce Clause and Necessary and Proper Clause holding, is it actually, or are they actually holdings? Because, of course, you had Roberts writing for himself and the four dissenters writing essentially the same things, but not joining Roberts. They didn't, I think that's a very easy question. I think there is a Commerce Clause and Necessary and Proper Clause holding. First, because there are 5 votes for the same thing. I mean, like if you go old school, you don't have anybody joining anybody. You just have them writing seriatim, right? And you have Judge so-and-so writing X and Judge so-and-so writing X, and there's 5 people writing X, but nobody joining each other. That still means there's 5 votes for X. Similar here. But also, there's an even easier way to get there, and that's in Part 3C, which has a majority of 5, Roberts plus the 4 liberals, lies the following statement. The court today holds that our Constitution protects us from federal regulation under the Commerce Clause so long as we abstain from the regulated activity. So there are 5 votes signed on officially for that proposition. So I think it is a holding. Now, whether it's dictum is and that's your question, that's a much closer question. I think it's not, because I take Roberts' opinion for what it says. And here's what he says. It's only because the Commerce Clause does not authorize such a command that it is necessary to reach the taxing power question. And it's only because we have a duty to construe a statute to save it. I can go on about why I think he misapplied the constitutional avoidance canon, but nevertheless, it's only because we have a duty to construe a statute to save it, if fairly possible, that Section 5000A, the unicorn thing, can be interpreted as a tax. Without deciding the Commerce Clause question, I would find no basis to adopt such a saving construction. So essentially he's saying, I only needed to rewrite the law because I first decided that it wasn't justifiable under the Commerce Clause. You can't sort of go through your Commerce Clause analysis, decide it doesn't fit, then decide it fits under taxing power, and then throw out that proceeding. They both kind of need to be there to get to where Roberts needs it to be there. And because he's the controlling vote, he kind of gets to say how he got there and therefore what the reasoning is.
So I agree with all of that except for the characterization of the law as a unicorn. But I want to add 2 things. One, in some sense, it's a almost entirely academic question, because it's clear there are 5 justices now who strongly take this view. And so any litigation reaching the court without a membership change of those 5 is going to be they're going to treat it as holding. If the court's membership changes at some point in the future, in the case it comes up again, if they're inclined to overrule it, sure, one of the arguments they might make is, and this was never really a holding, but that'll be opportunistic. Second point I would make is that there are a great many cases that are treated as law of the land in which you could make this argument even more strongly. So, for example, the Supreme Court has decided a great number of cases in which, or some cases anyway, in which they say, we find a right to X, but the defendants have qualified immunity in this particular circumstance. Well, technically, they didn't have to reach the question whether there was a right, because having found qualified immunity, they're denying recovery, and so is the holding dicta. No, we don't treat that as dicta at all. And prior to 1989, the Supreme Court routinely denied retroactive effect to some of its criminal procedure holdings in habeas corpus cases, and you could have therefore characterized those as dicta, but we just don't. That is to say, our practices treat lots of stuff which is arguably dicta as holding, and once we do it, we do it.
Go ahead. Oh, thanks. There were media reports after the Obamacare case came down that a couple of conservative justices came to the Chief Justice and tried to convince him to change his mind. I think this came from CBS News, and they were frustrated that he refused to change his mind. And you just mentioned that the conservative justices didn't sign on to any part of John Roberts' opinion, even the parts that they agreed with. Do you think that's sort of proof that they, in fact, were very frustrated with John Roberts' refusal to see reason as they saw it?
Well, I'm sure they were frustrated. I have no reason to disbelieve the stories about the leaks. Jan Crawford at CBS is a reputable, very reputable reporter whom I know and trust, and I'm sure that went on. Who knows who it was, whether it was clerks at the behest of justices or the wives of justices. I mean, that's all speculative. So I'm sure, but there's, the court decides big controversial cases, perhaps not quite as big as this one. And Justice Scalia has been on the record on TV and radio this summer saying how, we're adults. We'll this is all overblown. Well, it's not that they're going to, not sit at his table at the lunch hour or something like this. I don't think it'll affect, the dynamics of the court that much long term. And I don't think also neither that this is heralds, because Roberts is being shunned or was shunned temporarily or what have you, that now all of a sudden this is the beginning of his suitorization or something, or swing to the left. I don't think that at all. He's not that type of a thinker. I don't think. The leaks are troublesome. If the reports are, there's speculation again about why Roberts changed his mind. That's might be troublesome or not. Again, I think that it's for non-legal reasons, which is bad. But the mere fact that he changed his mind, justices do that all the time. So that should not concern anyone in particular. I
don't have a view. I think that, that doesn't stop me from talking. Number one, we don't know, right? And we probably will never know, or that is to say, those of us in the room, because by contrast with, Justices Marshall and Blackmun, who had their papers going public pretty quickly, all of the current justices have made deals basically to prevent the publication of their papers until, I think it's 100 years or 50 years after anybody they served with has died. Which I think is something of a disservice to, historians and, the curious like me. But there it is, and they're not going to talk about it. And
so when Justice Ted Cruz dies then or something?
Right.
We can be alive for that.
They can. I don't know about. Anyway, so we're just not going to know, and I think that it's true that it doesn't cast a long-term shadow.
I was just going to ask Mr. Shapiro actually a little bit about this Medicaid administrative thing, because it seems like you're saying, or you're conceding that the proposed kind of alternative is functionally the same, but that there's this kind of political hurdles that are going to prevent this kind of action from Congress. I'm curious what you think those political safeguards are in that context, and kind of pushing on what Professor Dorf said, how those differ specifically from the other political safeguards that Justice Ginsburg is kind of suggesting exist for the Commerce Clause.
Well, again, I haven't fully thought this through, and again, there could be viable suits by the states that they relied under administrative law or under. This gets us into realms of things that haven't, almost a constitutional crisis where you have, all the states all of a sudden going against the government because the Medicaid's being pulled and transformed, although some governors might go along with it. The political check is that this would, Congress would face explicitly, it would have to make arguments that we are removing Medicaid as we know it and putting in this other thing. And that is a heightened political gauntlet to run, just like it would be a heightened political gauntlet to impose a tax rather than a mandate. And so the political check would be greater, but it would seem to me under modern jurisprudence that it would be constitutional, more likely than not.
I'm going to ask you if there's perhaps a different reason to explain than constitutional law. After the Solicitor General's pillory for his performance, I came home and watched MSNBC, which I loved. And for the first 22 minutes of Rachel Maddow's show, she basically talked about Bush v. Gore and characterized it as a fundamentally political decision.
Another 7-2 decision.
That's tendentious.
The court was itself just a political animal, and that of course that any decision the court made was just political and partisan in nature. A couple days after that, the president spoke from the Rose Garden saying that to overturn it would be unprecedented because it was strongly passed without a Republican vote in the House. And so everyone was sort of expecting that this was going to happen, and people were starting to run against the Supreme Court in terms of how it was dealt with in political discourse. Roberts knows what's coming up in terms of the court rulings, the things that they've accepted. And I think it's possible that he wanted to shield the court from accusations of partisanship. And so he also, it seems to me, but I'd be interested in your view, with a 4-1-4 decision, didn't want to join the liberals in saying that this was empowered under the Commerce Clause. He basically rewrote the statute to call it to say it's a tax, even though the word is never used, and said that it's not the position of the court or the function of the court to save the people from the mistakes of their elected representatives. I think that was important in the ruling. And therefore, he said, if you want to change the law, you should change your elected representatives. It seems to me, at least you could make the case, and I'd be interested in your views, that he was looking at down the barrel of being the one guy who decided how 20% of the U.S. economy was ordered. And he really didn't want to do that. He thought that should be a political decision. I've also read that Roberts is a guy who plays a long game when he was a lawyer. And so by voting to keep it in place and not overturning it, what he effectively did was to give Republicans an issue to run against that they would overturn. And so what I wanted to ask you both was, do you think that political explanation is a better explanation of what happened than looking through the case law on both sides of it?
Right. So I reject that dichotomy, right? There are decades of very robust political science findings that say that you can account for about 80% of what the Supreme Court does in simple left-right ideological terms, right? And now it's much lower for lower courts because they don't have the docket control that the Supreme Court does. They're taking cases where the legal materials are, by their nature, ambiguous, right? And so what's going to have a role? Well, the justices' values. So even in cases where they are following the law, 80% of the variation is politics in the small p sense, not the big P, sort of not the partisan politics sense. I don't have access to the inside of Chief Justice Roberts' brain, but if I did, I would be very surprised if he were to agree with any of that. I think, and I would believe him. That is to say, I do not believe that he would consciously account for his motives in that way. Now, that's not to say it wasn't a factor, right? Because I don't think that any of the justices or judges think of their decision-making in personal, political, or partisan values terms. But, you know, the numbers don't lie. And so it could be true that I'm right and you're right? That is to say that all of those things were factors, and yet none of it ever entered the conscious stream of the Chief Justice's mind or any of the other 8 justices.
Well, I disagree with most of that. As I said at the beginning, I do think the decision by Roberts was mostly, if not all, non-legal. Whether it's small p politics, I don't think it was big P politics, but small p politics, or thinking about his own legacy, the court's reputation, et cetera, et cetera. I think in doing so, and by the way, it's curious that when, you know, if he had gone the other way and joined the dissenters and struck everything down, that they would have been acting politically, but the liberal justices acting in lockstep, that wouldn't be political, that would be principled. I mean, it just depends on which side you come from. But I think to the extent that those were factors in his thinking, I think he radically misjudged the situation, in that Obamacare, and especially the mandate, was unpopular and increasingly so from day one. There was a poll a couple of months before the decision that even a majority of Democrats thought that the mandate was unconstitutional. And to the extent that he cared about the court's reputation and not being seen as partisan and not making decisions based on small p politics, he miscalculated that. Respect for the court has gone down since the decision. People think that it makes, you know, because his decision has become viewed as some head-scratching, non-legal thing. That's in the short term, at least. Who knows what in his long game he might be brilliant in that respect, calculating the court's reputation. And that reinforces why we don't want judges playing politics and making their decisions based on those kinds of consideration. I mean, look, at the end of the day, we depend on our judges. Why do we care about the court's institutional integrity and reputation and independence in the first place? So that they are respected, so courts are respected, judges are respected, when they make tough calls in big controversial cases. And there's not a bigger case than this one. So I do think that some of that, I don't think it was because of pressure from Obama or the chairman of the Judiciary Committee, Patrick Leahy, or Jeff Rosen, or anybody else, media commentators. I don't think it's pressure from them that caused him to do that, but just his evaluation of the political scene, which unfortunately coincided with pressure from politicians and pundits, and therefore kind of sullies his decision, even if it was cleaner than it appears to be, did play a role, and that's why I think he only did himself and the court harm in deciding the way it did.
Can I say one last word? So it seems to me that's an extraordinary accusation made on virtually no evidence, right? So you take a much more formalist view than I do of how the court normally decides cases. I think that they have a kind of commitment at the conscious level to the sort of rule of law decided just on the legal arguments view, and that they do their best to do that, but they're human beings, and because they take cases in which, as I said, the legal materials are ambiguous, that gives a lot of room for their values to affect their decisions. But you take, and maybe you think that's true of normal decision making too, although you said you disagreed with just about everything I said earlier, and that was one of the
I think there's a correlation between values and constitutional theories.
Right. Justice Scalia has recently said that, and it seems to me it's nonsense for a reason I put on my blog, and I can refer to other people to that as well, which is to say that if that were so, you would see like you would see, for example, why is it that I can give you a list of 6 issues on which the liberal position results in striking down laws, and the liberals all want to strike down the laws, and then 6 issues in which the ideologically conservative position is strike down the laws, and the conservatives all do that, and the liberals flip, and they all do that. And none of them seems to correspond to originalism versus purposivism versus anything else. But put that aside. But the accusation you've made is just because you strongly disagree with Chief Justice Roberts, he, uniquely among the justices, was not following the law. I don't know how you can make that accusation.
Look, as Occam's razor, it's the most simple explanation for what happened. Because look, I more strongly than I disagree with him on the law, disagree with Ginsburg,
right.
Obviously. But I'm not accusing her of playing politics or thinking about anything other than the law. Ginsburg, I think, was acting more as a judge than Roberts was, even though I disagree with her legal writing more than I do with what Roberts wrote. Look, I have too much respect for Roberts to believe that his taxing power section was actually 100% heartfelt view of the law, because it simply doesn't compute. And I don't believe it's because he changed his mind with 3 days before the decision was supposed to be released, and therefore he only had 3 days for him and his clerks to come up with it, or something like that. I mean, you read the section, and it's just so, and you see the conservatives that try to bend over backwards defending it because to resolve the cognitive dissonance in their minds or something like that. And it just simply does not compute. It's a decision that, again, is good for that train only. He posed the conundrum for himself that he did not want to expand federal power while letting the federal government get an ultimate bottom line victory here. And that's what he came up with. So that might have been brilliant in terms of strategy and what have you, but it's not law.
Yeah. I guess it seems to me that is underwritten by a view that the taxing power was just not a plausible way to sustain this law. And the government filed briefs in the lower courts all throughout doing that. It was, as was repeatedly characterized as a view that was a favorite among the legal academy. So, I happen to think his opinion, his analysis of the taxing power isn't bad. That we didn't have a jurisprudence of labels before, and we still don't. It's impossible to draw a straight line through all the cases, because some of the cases say they're adhering to the earlier cases, but really do something a little differently. So you're putting an awful lot on what seems to me your legal analysis, which one could characterize simply as a strong disagreement. And after all, he got 5 votes on the taxing power.
Grudgingly, because the liberals wanted to uphold it willy-nilly. I mean, regardless of what the argument would have been. I mean, Ginsburg was the most anti-tax power justice at oral argument. And indeed, when she was announcing her dissent, her partial dissent from the bench, the day that the opinion was announced, I was writing my kind of reaction statement, press statement, while she was doing that, because I'd already listened to Roberts and Kennedy, and I knew what she was going to say. But it was kind of like, and again, this is just my kind of subjective view of what she seemed to be all along saying about this was, yeah, we'll go along. That's kind of, she seemed skeptical about it. I mean, yeah, they needed to vote that way to go along with it. But nobody. No. Well, yeah, to the extent that the liberals went along with the taxing power when they didn't really agree with the taxing power, sure. But when your ultimate view is the federal government can do whatever it wants anyway, it doesn't matter how you address it, as long as it doesn't violate the First or Fourth Amendment, or there's a political check and what have you. But look, no academic, not even Jack Balkin, who's had the most sophisticated view of the taxing power justification for this all along, articulate it this way. All of the academics, and indeed most of them who I debated all over the course of the last 2 years, did favor the taxing power argument over the Commerce Clause argument. But they said that it is a tax, just like it's a regulation. It's a tax. It can be justified in any which way. You don't have to rewrite it. You don't have to apply the constitutional avoidance canon. You don't have to consider it a choice or the scienter or any of these things that Roberts was talking about, or define whether it's a direct tax or not. They didn't care about any of that. They just thought, well, look, it's money's involved. The IRS runs it. It's a tax. I mean, I guess you could say, bottom line, yeah, they were pushing the taxing power argument, but that is not what the Solicitor General ultimately, I guess it was back up to 6 pages of taxing power briefing that he included in his last brief. I mean, really, what Roberts should have done, if that's what he was serious about doing, is called for further briefing specifically on that issue, if that's what he was going to hang his hat on. But to decide an issue of that magnitude with so idiosyncratically in one of these 414s, when there was so little briefing and so little time devoted to argument and nobody was taking it seriously, is again points to the idea that he wasn't doing this on the law.
I think we go back and forth all night on that, so we're going to stop there and bring Dean Schwab up with his closing remarks.
Well, I just want to thank everybody. It's a great way to start the semester with sort of a vigorous debate in the new year. We want to sort of thank our panelists for coming, the officers of the Fellow Society. I agree with what Professor Dorf said at the opening. I think sort of forum debates like this are sort of one of the exciting intellectual parts of the law school. So I applaud for